Thanks for joining us for In Focus tonight. Last week, a grand jury indicted the 6 Baltimore officers charged with the death of Freddie Gray on slightly different charges. The false imprisonment charge for 2 of the officers was not returned. Now, some legal experts say that means either the state's attorney chose not to pursue the allegation that Gray's arrest was illegal, or the grand jury felt the arrest of Freddie Gray that morning was justified. In Focus investigator Brian Kubler explains.
Some lawyers say that means the business about whether or not the knife was illegal or if the officers should have chased Gray at all is now off the table. Now, many of the charges could come down to how Gray was transported and treated, and perhaps what the officers knew about taking a person into custody and when they knew it.
The statement of probable cause is as follows.
In her news conference earlier this month announcing charges against the 6 police officers suspected in the death of Freddie Gray, Baltimore State's Attorney Marilyn Mosby was clear. Freddie Gray was unrestrained in the back of that police wagon despite an existing Baltimore Police General Order. The state's attorney made mention of it several times.
And proceeded toward the central booking and intake facility with Mr. Gray still unsecured by a seatbelt, contrary to a BPD General Order.
Mosby said officers failed to restrain Gray at least 5 times during the wagon's route, and that, again, not doing so was a violation of an existing BPD General Order. That order is number 1114, and it is clear. It reads, quote, all passengers, regardless of age and seat location, shall be restrained by seat belts or other authorized restraining devices. But what may not be clear is whether or not the officers involved knew that order existed. No, he ain't all right. The persons in police custody order had been recently revised. Before the rewrite, restraining a prisoner was done at the discretion of the officer, but now there was a new word in the 15-page rule: prisoners shall be restrained. While it is widely reported that order was rewritten just 9 days before Gray's arrest, as we first reported last week, it wasn't approved and sent out to rank and file until much later. ABC 2 News obtained the department-wide email showing the timestamp of 6:01 p.m. on April 9th. Just 2 full days before Gray's arrest, Policy 1114, along with 5 others, were emailed out in the commissioner-authorized distribution. Last week, Commissioner Anthony Batts said email is the first method the department uses to push out its new orders.
Our policies are disseminated now through emails. That's the easiest, fastest way using technology to get them out. We also have them in paper form. We also send them out to the sergeants, lieutenants, at roll call to go over them to explain and answer any questions that we may have. Baltimore police commanders then typically read the new orders at roll call for 3 to 5 days. ABC 2 News obtained a copy of that email to commanders as well. Sent out the morning of April 14th, 2 days after Gray was hospitalized, it reads, per Policy 1114, please ensure that all prisoners are properly secured. It goes on. Please ensure this is read at roll call for 5 consecutive days.
And that's really the missing piece for us to...
For some defense attorneys familiar with the case, that slim timeline can raise an important question as to whether or not 2 days was enough time for a bureaucracy like the BPD to finish notifying its entire force of a new and important policy.
I would think that they would look into what officers knew what and by when about the rules, but keep in mind, a lot of the area police departments don't even have this rule. If this is such an established standard, why had it been a rule for 3 or 5 days?
Andy Alperstein is a former Baltimore assistant state's attorney. He says the timeline of what officers knew when is important, but bigger still is whether or not seatbelting someone rises to the level of murder.
Just because somebody doesn't seatbelt somebody doesn't mean that you have a breach of a legal requirement or duty of care that's going to lead to a murder charge. I mean, take that to its extreme, Brian. Think about, you know, a parent who has a duty of care to their passenger child and they have an accident and it's their fault and the child dies. Are we going to now start charging them with second-degree murder?
Now, it's important to note the Baltimore Police Department says once a policy is emailed out, it immediately becomes effective, and that officers are responsible for keeping up with new rules and regulations. We reached out to the Baltimore State's attorney for this story, but the office has not commented.